ये जो पासवर्ड
Good evening, everybody. Good evening, everyone. I see Pallavi Agarwal from Lucknow. Delighted to welcome you all on today's interesting webinar hosted by JIPA in association with National Company Law Tribunal Bar Association, covering the nitty-gritty and challenges faced by resolution professionals to overcome financial distress and running the business. Managing a business is challenging at the best of the times. But when a company is in distress, facing financial hardship leading to bankruptcy, the task is exponentially more difficult. From evaluating your business model to making tough financial decisions, it can be troublesome task. But of course, it's not impossible. With the right step and strategy, you can lead a declining company back to profitability and stability. Once the problem have been identified, you need to develop a robust turnaround strategy. This should involve a clear plan from addressing the company's biggest problem and creating a path toward profitability. It's crucial that this plan is realistic with the milestone and goals. The first step in saving distressed companies is to identify the root cause or its distress. Is it lack of revenue? Is it poor customer satisfaction? Or it is internal operational inefficiency? Understanding what's wrong is critical to finding a solution. Conduct a thorough review of financial statement, customer feedback, and operational processes to identify
दोबारा से
areas
भेज
for
दिया नहीं
improvement to pull the company. I feel one should remain focused on their goal and not lead to negativity or doubt from other hinder your progress. Encouragement comes from within, as does motivation. So trust in your own ability and push toward accomplishing your goals, regardless of what other may say. This mantra, along with the right strategy, can one day trace the path to a unicorn. And to get this right strategy, we here at JIPA try to create a learning environment for you all, where we can learn together and reach new milestone. As a part of JIPA Professional Association, we provide you with timely topics and interesting speaker. Here today we have our guest of honor, Dr. UK Chaudhary, and our expert advocate Maya Gupta and Manisha Chaudhary to guide us with the best strategies. So I welcome you all, and now I will request Praveen sir.
Because if you read Article 7, it also says subject to the provisions of any law for the time being in force. So in that light, the Supreme Court, I know, has written this judgment. In my view, the primary
I think something
was the financial implication
on the
of the
back
judgment.
side, something Mr. Anupam Larry is coming out to be there. अब सबको जरा म्यूट कर दो पल्लवी जी, then परवीन जी का कुछ इशू है शायद, इस करके वो लॉग इन नहीं कर पा रहे, जब उन्होंने करा है तो वो आवाज नहीं उनकी आ पा रही.
जब तक कि our guest of honor Praveen sir joins back, I would like to introduce our first speaker of the day, Advocate Maya Gupta. Advocate Maya Gupta is an insolvency professional specializing in IBC matter, corporate laws, commercial transaction, and civil dispute with 18 years of vast experience. She has successfully resolved numerous insolvent companies and implemented solution plans. Welcome, ma'am. I'm sure the audience will greatly be benefit with your experience and insights, and your strategy will help them safeguard their business. Now, floor is all yours, ma'am.
Thank you, everyone. Thank you, ma'am. Good evening, everyone. Welcome to this present session on the challenges faced by IPs for carrying the CIP process. I thank you all for joining us today. As ma'am has introduced me, and I have successfully completed CIRP case and I'm pleased to share you through my journey and share insight the practical aspects of managing insolvency and bankruptcy cases across various industries. So I request have a kind attention of all the participants. Before we dive into specifics, let me briefly outline what we will cover today. We will explore the objectives of the CIP, discuss our experience handling different types of cases, and highlight the challenges we face as insolvency professionals in roles such as interim resolution professional, and liquidator. The objective behind today's session is to have the insight about the challenges that are being faced by the IPs, because as you all aware that the corporate debtors have their unique features, and the standard procedures that has been shared is not unique
Ma'am,
for all the companies.
my ma'am, just sorry to interrupt you between. We have within us Manoj Kumar Anand sir. Welcome, sir.
हाँ जी, हाँ जी.
Because of his busy schedule, he will be he is within he has joined us for a few minutes. So I would like him to say few kind words for.
Sorry, Maya ji, it's a really unnecessary interruption. But actually, Palvi forgot to said to me, because मैंने शुरू में कहा था कि मेरे को शुरू के 4-5 मिनट दे देना, so that I can share my experience there, and welcome you also, since you and Manisha is our the learned and welcoming speaker, and I'm seeing that people like you are really enlightened, and आप लोग कैसे इतना stress manage कर लेती हो being a lady, yeah, this insolvency. I have also handled a lot of cases, but stress is really enormous, especially all people are doing our other practice also. You be also doing your company secretary practice also. In any case, चलिए अब जो मेरे को 2-4-5 मिनट मेरे को कह रहा था वो ये था, our topic is the challenges faced by RP to overcome financial distress and running the business. Our name is IP being insolvency professional, but the moment we are appointed, our name changes. We become either IRP or RP. I should not use liquidator word at present, meaning thereby resolution professional. If we see, our basic qualification, हमारे को एग्जाम पास करने से पहले 10 से 15 साल का मिनिमम एक्सपीरियंस चाहिए, and that embedded with passing of this exam really makes make us very solid to face all the challenges in the IBC assignments. In fact, I tell you, 6 months ago, I was at Singapore, and on some IBC seminar conducted by our institute only, I heard the story from Big Four RPs, and one of the story which I was really impressed was that they said कि Jet Airways के जो owner थे वो कंपनी को छोड़ के भाग गए थे, because a lot of running expenses are there, and there's they couldn't maintain the aeroplanes and all this thing there, but they converted that company into a profitable company, and that is a very big example in our IP fraternity, along with initial trial companies कि कैसे ये successfully IPs ने businesses को convert करा. But we people are SME. I shouldn't call ourselves small, but I shall call ourselves small and medium enterprises. We do get assignments which are also of small and medium enterprises. Here, challenges are absolutely different. For example, I also got some small assignment. कोई कैश बैंक में बैलेंस नहीं होता, कोई कैश में आपके पास नहीं होता. इनफैक्ट इन वन ऑफ माय प्रेजेंट असाइनमेंट वेयर आई एम ए लिक्विडेटर, डायरेक्टर ने इतनी भी वो क्या कहते हैं कोऑपरेशन नहीं करी कि जो किताबों में 5-5.5 लाख के करीब कैश इन आ रहा था वो आरपी को आईआरपी को जब मेरे को दे दे, नहीं दिया उसने. एंड फॉरगेट अबाउट देयर आर अराउंड 83-84 crores of asset which has wiped off or gone in the air. No doubt, as an RP, he filed, I am a liquidator, he was an RP there. He filed as usual 43, 45, 46 the application, awarders application. But I don't think so. It will be really a nightmare if you get able to get any recovery out of that. Even during whole CRP process, 180, 270, or 3-4 months after that, or a year after in liquidation. What happened is that I don't blame the COC people also. Why? Because why should they spend good money after bad money? But it is only the cost to them, and expectation of recovery is very, very low. Now let's go to another part. Interim finance. COC never come forward. If we knock to the ARC or NBFC for some interim for the finance, we do get. If you have underlying assets, we do get. But I should say that is again a very hard nut to crack. Then how to pay our security staff, lawyers, accountants, ourselves also. As I said, if there are assets, then you are able to run it. यही होता है कि चलो ये 2 3 4 साल के बाद जब भी ये assets बिकेंगे या साल के बाद बिकेंगे, तो then we be able to pay all these things. Till then we go on investing. Or in fact, I was feeling कि during such sort of companies, जैसे एक हमारे से पहले ये क्या कहते हैं, प्रमोटर्स अपने कैडर्स को फेस कर रहे थे, वैसे ही हम लोग उन सब लोगों को फेस कर रहे होते हैं ड्यूरिंग अवर CRP पीरियड आल्सो, बिकॉज ऑफ द नॉट हैविंग फंड. तो ये एक बहुत बड़ा चैलेंज है SME सेक्टर्स के साथ. Now I moved, we are 7+ years. इसका solution क्या है? Let's look into the solution for it. Our IBC rhythm is not 7+ years old now, even more than that. We are successfully running unclaimed dividend account. Why not our regulator have similar sort of some financing to such companies? I have been raising this issue to many platforms. Again, I'm raising this issue herein because ultimate responsibility of running this IBC show is of regulator. No doubt, we are the facilitator, but ultimate responsibility is of the regulator. Regulator must think on, doing this thing there. And I would request my speakers to enlighten us if what is happening abroad. In Europe also they be facing same problem. USA, Singapore, and maybe Australia also. तो वहां पे इस तरह की कंपनीज के लिए क्या एक रेगुलेटर या एक क्या सिस्टम है, क्या नेटवर्किंग है, हाउ दे आर हैंडलिंग सच सिचुएशंस. Second part is that running serious business which he could not run is again a real nightmare. As expected, employees are honest to the past management only. But we need to motivate them and try to have their cordial relations, and then along with in fact the board of directors also. Even in this case also, I'm telling you, यहाँ पे ये है कि मैंने जितने भी आज के डेट तक अराउंड 35 के करीब मैंने केसेस हैंडल कर रहे हैं, मी एंड माई विद अदर एसोसिएट. तो मेरे को एम्प्लॉइज के साथ सस्पेंडेड बोर्ड ऑफ डायरेक्टर्स के साथ ज्यादा प्रॉब्लम नहीं आई, बिकॉज मेरे को ये लगता है कि मेरे को इन्हीं से ही इंफॉर्मेशन लेके आगे अपना प्रोसेस स्टार्ट करना है. Another factor is that, as you were just telling, that we should understand the key factors of the business. लेकिन अब पता कहाँ से ले हम? From where we should know. Me is a chartered accountant. My earlier clients were in the liquor business or construction business. And if I get some home baskets, from where I should know about that? तो इसके लिए आजकल what idea I can give is that you, my learned speaker Manisha ji and Maya can also add to it. The best is we can what I do. Google is a very good search engine. You can get a lot of information from there. Friends, clients. WhatsApp group is sometimes are also really helpful. Or IPs was worked in the same industry. When I get first appointment in my home bias case, तो जो IPs ने already home bias case कर रहे थे या कर चुके थे, they really helped me how to root through it. So these are my situations there. अगर इन सब के करने के बाद भी हम लोग नहीं कुछ कर पाते, उसको गोइंग कंसर्न या उस कंपनी को नहीं रन कर पाते, तो आई थिंक देन वी शुड गो फॉर हम उसके साथ चिपके ना रहे, we should go for the liquidation or maybe the early dissolution as per our liquidation regulation 14. Another suggestion is that any asset which has a very huge book value but which does not exist, or it might have been siphoned off. जैसे generally मैंने देखा है स्टॉक जो होता है वो siphon off कर देते हैं प्रमोटर, और तो फिर उसको अगर हम उसकी कोई वैल्यू ले लें तो फिर उसको रेगुलेशन 37E के अंदर NRRA में बेचने में बड़ी दिक्कत आती है. तो एसेट मेमोरेंडम एक बार हमने जो वैल्यू ले ली, फिर उसके बाद उसको जब भी आपको उसको बेचना है तो आपको 25% 10% करके ही ऑप्शन करना पड़ता है. तो एसेट मेमोरेंडम जो बेसिस है वो हमारा होता है वैल्यूअर्स रिपोर्ट. तो वैल्यूअर्स रिपोर्ट के अंदर जब हम इस तरह के एसेट्स को बनाएं तो ट्राई टू हैव इट एज अ वेरी वेरी मिनिमम वैल्यू. आई थिंक आई स्पोकन अ लॉट more than my allotted time. I leave it to my rest of the speakers, Maya ji and Manisha ji, to enlighten us more on it. और इसमें मैं आपको एक बात थोड़ी सी और ऐड करना चाहूंगा कि कमिंग ट्यूसडे को आई एम आल्सो टेकिंग वेबिनार ऑन PG. PG is a quite hot topic nowadays, personal concerns to corporate debtor. तो लिंक मैं परवीन जी के थ्रू सबको भेज दूंगा. तो 4 से 5:30 बजे का है. इट इज it's basically tax federation people have invited me, so I be speaking on their behalf. So do join us. और thank you very much. परवीन जी आपको, पल्लवी जी आपको, और माया जी को आपको सबसे ज्यादा, because I just delve into your saying, but I thought I'm productive. So please carry on.
थैंक यू सर, थैंक यू सो मच फॉर मतलब आपने जो हमारी एक हम लोगों के लिए प्लेटफॉर्म क्रिएट कर दिया है. नाउ वी विल एबल टू अंडरस्टैंड मोर आवर learned speakers. Sorry, Maya ma'am, for the interruption. Now you may proceed ahead. And for the information of this
Manoj,
participants, are
you have
जी माया जी
yes.
सर.
Yes, ma'am. Thank you, Manoj. You have really enlightened the basic difficulties that the RPs are being facing. And as you have stated that you have not faced too much of difficulties with your cases with the management, that the same was with me also. In some cases, there was faced the very limited difficulties, but rest of the matter you learn. Then you when you do the work, you learn the work. So this is the basic thing that we do in our CIRP matters. Now come to the matter that for which all are waiting. So we have managed various CRP cases, including real estate, heavy industry setups, and companies in the entertainment sector as well. See, there are various industries in the India, and each sector has their unique features. As you know that the law is made as a standard, but it cannot be implemented in all the sectors. So since the law is evolving, so based on the requirement of each sector, the law is required to be changed accordingly. So now comes to the points that the challenges that being faced by the IPs in various roles, say as an interim resolution professional, as an resolution professional, or as an liquidator if the company enters into the liquidation. So basically there have been various practical aspects and challenges being faced at each and every stage. Once you appointed as an IRP, there is a timeline of 30, that the period of IRP is given as 30 days as per the provisions of the law. And in that 30 days, the work that whether the company is viable or not, whether there has been assets or not, and how many stakeholders, claimants are available in the company. So since this is a very initial and a crucial stage, so first of all, the challenges that faced by the IPs when he was appointed as an IRP. So the first challenge that is faced by the IP, that whether he received the intimation of appointment as soon as the order passed. Say if there has been delay for more than 3 days, but there has been no say under the provisions of the IDC that the 180 days need to be commenced from the date when the order is passed. But now with the practical uh, challenges, the court has also
Ma'am, I guess there's some connectivity problem.
consider that and understand the situation. It has allowed the assignment from the date. Sorry,
Ma'am,
ma'am.
sorry, ma'am, we are unable to hear
Am I
you.
audible?
Ma'am, I
Yes.
guess there's connectivity problem. Maybe you switch off your video, then it's be more clear.
Okay. Okay, I'll stop my video. Okay. Yes. So is it now audible?
Yes, now it's better, ma'am.
Okay, okay.
Ma'am,
Yes.
can you
So the
repeat
initial
the last
challenge
line?
that we faced as an IRP. Yes. So as I have submitted that when the order of CIRP is passed, if the IP gets the notification intimation of appointment as an IRP within the prescribed period of public announcement of say 3 days, then it's okay. If the period goes beyond that 3 days of intimation, then the IP needs to start the work as soon as it comes to its knowledge. And he also required to submit a report with the IBBI as well as the Honorable NCLT about the intimation of appointment, so that the law that prevails for giving the public announcement in relation to the CIRP could not be breached, and he could start his work to conclude the same within 180 days, 270 or 330 days, as a case may be. So since the CIRP commencement date is the benchmark for following all the provisions of the law, that needs to be carefully noticed by the IP, and also required to follow the procedural aspect and the timeline that is provided under the regulation. Now we come to the managing compliance, because after appointment of the IRP, that it needs to make the legal compliances, and he is to strictly follow the court orders, regulations, and the code of conduct. And if that IRP or the RP is found any breach in compliance with the same, then the IBBI, then the actions led by the IBBI against the IPs, as you have seen in many cases, that IBBI is sending show cause notice for non-compliant as well. So this is the biggest challenge initially need to be faced by the IP, that the compliance part need to be completed, as well as filing and reporting. As prescribed under the provisions, that regular filing and reporting must be done at the IBBI website, and also before the Honorable NCLT, so that you will be saved from non-compliance issue. The next hurdle that challenges that faced by the IPs in relation to taking over the position of the assets of the corporate debtor. As you all aware that the corporate debtor, the suspended directors, the ex-management, and all the related management takes away all the assets, whatever available in the books of the company, or the value that may be fetched in the company at the time of filing of application by the claimant. So it is very difficult for the IP to get the possession of the assets of the corporate debtor, because at the end, when it comes to the IRP appointed, he came to know that there is nothing available in the actual available in the company, because whatever the data year or two back, then it comes to know after scrutinizing the public records, say from the MCA website, GST data, income tax data, or from the banks, then it came to know by the IP that there is nothing available in the company, and only certain assets are there, which has a very minimum value, and in some cases that realizable value of those assets is more than the CIP cost. So this is, in some cases, this is a basic hurdle when there is no assets available in the company. So that the biggest, this is the challenge, and this, to overcome this challenge, the IP should, initiate the proceedings as soon as possible if it came to its knowledge, with the confidence of the committee of creditors. Look, there is a limited assets available in the company, and to get the way forward to deal with those assets. If the COC is of the view that to get rid of these assets by making auction, then immediately IP is required to file a suitable application, so that the CIP cost could be curtailed and the value maximized could be possible for the stakeholders. In some cases, there has been assets attached with the ED or any government authorities due to any non-compliance by the company. In those cases, as you all aware that if any property is attached by the ED, then it takes more than 2 to 5 years to detach that property, because the government and the ED reviews each and every angle why these frauds have been done in the company, and due to certain because this public money is involved with those assets, they are not eager to detach those assets. But in some cases, now another challenge apart from taking possession that faced by the IPs is the non-cooperation by the ex-management. As you all aware that since due to the acts of the management or the suspended directors, the company is faced to the insolvency resolution matters. And also they have done various frauds in the company and siphoning of the funds from the company. So, so that in order to not to get the detail by the IPs, because the IP takes away all the records and all the books of accounts. So they do not cooperate to the IP, and they do not provide the information which is very essential for carrying the CIP process, because only the suspended directors or the ex-management could submit the real picture of the company. And IP being a third person may not be aware of the working of management and the process that being followed inside. To overcome this challenge, the IPs are suggested to take away the available information from the public domain as well as from the professionals. Those they found that the certain professionals have signed any balance sheet, any audit report, or other document, valuation, etc., so that he could come to know about the available records, available information. Apart from those professionals, when the IP invite the claims from the stakeholders, the IPs also get the information from the claimants as well, that and they submit the real picture, and they also are in a position to provide the corresponding details with the stakeholder, with the suspended directors, because they have been in day-to-day touch with the management. The next challenge that the IPs face while pursuing the CIP process is an interim finance. The funding is a big challenge that are being faced by the IPs, our fellow friends, in carrying the CIP process. Luckily, the Honorable NCLT has allowed to pass orders for giving direction to the applicant to submit rupees 2 lakh initially to carry the initial funding, because COC constitution takes time and the IPs initially is to incur the expenses, say the public announcement, formation of COC, and other petty expenses that is required at the initial stage. So within that period itself, IP get to know about the company and the available assets. So based on the available claims that it has received, it can conclude that how much assets are available in the company, and can also find submit before the COC members the whereabouts of the company, so that the process can be run through. Say if there have been assets, then the suitably information memorandum is prepared for inviting the expression of interest. So if these informations are available at the initial stage, then the funding challenges could be meet out, because say in case of operational creditor is the only COC member, then this is their IPs face a big challenge, because operational creditor do not fund the CIP process cost. It on the ground that it has already suffered a lot while the company was running, and also in the litigation part as well. If nothing is available in the company, then he abscond itself for meeting the litigation cost, for meeting the CIP cost as well. So in that case, the IP is required to file necessary applications before the Honorable NCLT that these companies' assets are insufficient to meet the CIP cost and to get the directions from the Honorable NCLT accordingly. There in cases there has been assets, then the IP can make certain arrangements and take a pro bono services from various professionals like advocates, chartered accountants, valuers and others to make the payment at a later stage. So accordingly, this funding challenge that is required for running the CIRP matter could be meet out at the end. IP is to take precautions because the cost factor should be get submitted before the COC at each and every stage. Else, the COC might deny at subsequent stage that the cost that has been incurred by the IP is not approved by the COC. Now, the regulation itself has mentioned it clearly that the IPs is required to conduct a monthly meeting and to that no penalty could be taken up for the subsequent period and the COC member cannot submit that they are not aware of the expenses that has been done by the IP on its own. So friends, you need to take to be very cautious while incurring any expense for relating to the CIP process. Now, there has been challenges for recovery of the assets. As you are aware that assets might be of the different classes like movable assets, non-movable assets. So for movable assets and non-movable assets, there is also required a prior approval. If the CD has an assets that has obsolete or has negligible value. So with the consent of the COC as well as approval from the Honorable NCLT and based on the valuation that has been done by the valuer, that asset could be sold as soon as possible in order to curtail the cost rent part of the obsolete assets and to fetch certain value so that the cost CIP running cost for those obsolete assets could be reduced. And if it is in case it is a fixed assets, then there is required to search the nature of that asset, whether it is not whether it is attached with some other authority or it is belongs, and if that assets cannot be sold in the open market, then that could be sold among the stakeholders with the permission of the COC as well as from the approval of the Honorable NCLT. In cases where company has a going concern, then it's the duty of the RP, its value. So again, the fund implementation challenges came, but with the expert knowledge of the COC members and the available expertise available in the market, the company could get good value if that is run as a going concern. As you said also, in some cases, when this resolution plan is approved, then there has approved. Yes, ma'am.
Maybe your connection
Yes.
is unstable and your voice is coming in.
Okay. Yes. Now it's audible. Give me a minute. I'll connection. I hope it is now audible.
Yes, ma'am. Much better.
Yes,
Thank you.
yes, ma'am. I'm so sorry there's network connectivity. Yes. Now, since as you all know that there are various challenges that the IPs face during the CIRP, and when the plan gets approved, then there is again challenges faced by the IPs in implementation. Say, if the COC member have approved the resolution plan, but the honorable but it takes time NCLT. So due to the time constraint, the resolution applicant may take back its steps for implementation thereof. As you have seen in the COVID period as well, many resolution applicants have submitted before the NCLT that they are not capable of taking this company as a going concern because of certain factors, because of valuation goes down, and due to the various other factors. So in those cases, the work that has been done by the IP during that period to get resolution of the plan, to get approval from the plan, become zero when the RA takes back its steps. Now, luckily, in cases, now since the economy is booming and the resolution applicant are coming forward to again submit the resolution plan for the company as a going concern. But again, there have been IPs are being facing challenges for implementation. Say for funding, initially, when the resolution applicant say mention implementation period say for 30 days, but subsequent period after say 6 months or 8 months or 1 year, when this plan gets approved by the honorable NCLT, then the financial position of that is resolution applicant goes down, or some miss happening in its business. Then again that implementation challenges came into the picture. So for that again IPs need to face challenges to get implementation and to file necessary applications before the honorable NCLT and to take permission to get delay implementation. So various factors that the CIR that the CIRP process being faced by the IPs in running these resolution of the company and get holders. Variability among the CIRP cases and vary from company to company. So same funda, same working cannot be implemented for each and every corporate debtor because they have their unique challenges and those are not standardized. Each requires specific strategies to address its particular issue. Now this as navigating CIRP involves handling complex and varied challenges. It requires a deep understanding of legal, financial, and operational aspects. As an insolvency professional, maintaining compliance with the IPC and ensuring effective communication with all the stakeholders are crucial for the successful resolution or the liquidation of the corporate debtor. At the end, I thank you everyone for your attention and participation today. As I have submitted that we have covered the fundamental objectives of the CIRP process and share practical insight for our experience across various industries. So I hand over to Vandana ji to sum up this.
Thank you, Maya ji. Thank you so much for a very insightful and interesting topic. आपने बहुत comprehensive way में you covered so beautifully about the CIRP extent. Now, moving ahead, I would like to introduce our second speaker of the day, Ms. Manisha Chaudhary. She is a managing partner at UKCA. Her forties lie in the field of general corporate advisory, writs, litigation, negotiations, corporate restructuring, merger and acquisition, etc. She did her certificate course in corporate law and governance from London School of Economics. Warm welcome, ma'am. I'm sure we all will be benefit with your vast knowledge. The floor is all yours, ma'am.
Thank you for having me here. First of all, sincere apologies from Dr. UK Chaudhary. He had been trying to join in, but he could not. So he has asked me to forward his apologies to you all. And maybe in the next session, he'll be able to join in. And hopefully I'll be there to help him as well. Now, Maya, now just coming to the topic, I think we're going to try to limit it to the topic which was provided to us. Apart from what Maya ji has covered, I sort of have summarized, according to me, what are the issues which are faced by the RPs and liquidators in total in the entire process. So just going by them one by one first, and then sort of coming up with solutions. And I would like that we make it a little more interactive. And if somebody wants to join in and give more solutions, that would be great. But just one of the first things is, of course, apart from the practical issues being faced by each of the RPs in each company, which is that the timelines have to be followed, which I believe more or less most RPs are able to do. I think that one of the biggest things is the interim finance, which is where the problem is being faced by the RPs of how they need to run these companies while they are appointed, and they don't have the access to documentation, anything like that. Now here, a lot of banks, NBFCs, everybody is not really in favor of providing this interim finance to the RPs. This was first discussed by the IBBI in 2017, about an year after the IBBI code, the IB code came into being. And the IBBI had recognized this interim finance as one of the first problems. And even till date, there is no concrete solution to that. There is no solution, though the courts have tried to help. RPs have in their own right tried to approach the forums, tried to approach different banks, NBFCs, the funds. None of them seem to be in favor of providing this fund, interim financing, to these distressed entities or to the RPs, despite the fact that this would be one of the first payments which will come out of any resolution process or even during liquidation. Having said that, why that is not being done, or where is the issue that is coming? One of the first one is that interest payment component of it, that once the liquidation starts, only till a year or till the liquidation takes place and the assets are sold, whichever is earlier, that will be the period in which the interest will be calculated and paid on this interim finance. The people who want to provide this interim finance are taking a huge risk. According to us, according to limited people in the industry, we would agree on the fact that they deserve to have more interest, or because the risk factor is so much in terms of their payments, they need to have more, the interest component of it has to be more lucrative for them. They cannot simply just give money out to the public basis the fact that, to the IPs, basis the fact that there is no return on their investment, or then there's no return on it. So the first solution to be found is to find and to give them that comfort that when an interim finance would be given, it would be ensured that the money provided is first of all protected, which the Act and the guidelines do so. However, any return on that will also be protected and will be lucrative. Only then will you see people or banks or funds to be coming and giving in this money. Anywhere abroad, and I think Mr. Anand wanted us to discuss this, abroad, this is exactly what happens. They are giving it at a high rate of interest, and they are assured that the money will be coming back to them first of all, the rate of return and the fact that there will be a return of their money. Both is ensured to them, and it's made sure that when they're financing, they will make a hefty profit, if you would like to call it, on this investment of theirs or on these loans which are forwarded as interim finance. That is where, number one, we are missing out. And that is why our financial institutions are not being open to this fact, whereas they did make desks for this exact financing. But nobody really is being able to channel it and to access it the way it was thought it will be. Secondly, when it comes to foreign financing, there are so many lacunas in the amount of money that can be brought in. Secondly, there is problem as to what will happen to the assets if this financing is not returned. Thirdly, the lock-in periods of these financings. Now, all of these 3-4 factors need to be discussed with the stakeholders as to how to solve it, so that if a foreign entity or a foreign financial institution, bank, fund, VC fund, PE fund, funds which are specifically mentioned for interim financing, if they want to do they want to solve such a situation here into India, how can we protect them, all the while protecting our processes and the assets and the companies here? Because we also do not want assets to be held by foreign entities while they're in India. So these 2-3 things could be one of the first ways to sort of solve the interim finance issue. The fact that the NCLT asks for certain minimum amount of payments of say 2 lakh, 3 lakh, I don't think that is enough for the RPs to run these entities. They could be huge companies. Even the basic cost of holding a COC meeting might be running into a lakh at least, because there's so many members to be involved. There's so many things to be done, so many nitty-gritties to be followed. It's not enough money to run entities. Now, what apart from, like what is that I see as an interim finance also is that we need to help the RPs consolidate the finances which are in the company itself at the stage 1. Of course, we have seen multiple examples of the fact that there is nothing left into the entity. The predator, the ex-management is not in favor of helping the RPs. They are antagonists to the RP, if nothing else. And they make sure that the RP is not able to get their hands on the right information on the money, on the bank accounts. They don't know where the assets are located. In fact, we are doing so many cases where there are multiple assets of a company, but for the RP to just locate those assets, it's a task by itself. The RP has no idea what litigation is going on what assets, who has a charge, where are they encumbered. All of this information needs to be provided to the RP instead of them doing a fact-finding situation, finding themselves in a fact-finding situation. That is not really the job that they need to first do and then be able to do the CIRP process, given the fact that everything is bound in a timeline for them. So creating more issues for the RPs and not really providing any outside help to them is where another problem is being faced in terms of information, in terms of consolidating assets, in terms of finding money, in terms of finding documents. And this all is interrelated to each other. It's not that one aspect of it being solved will move on to the next aspect. No, it has to be a consolidated effort to solve all these issues in sync with each other. Now, one of the first solution, of course, for interim finance, we've mentioned that we need to bring in and allow foreign funds. We need to get more guidelines on the fact that if an Indian fund is giving money, what is that they will be able to do? Banks need to be helped. However, maybe setting up a government-assisted fund can also be an answer to this. The government-assisted fund's first job is that it is not looking per se to make a profit as such. The idea would be to provide at a decent rate of interest money to the RPs to make sure that they are able to run these entities while the CIRP or the liquidation is going on. The interest rate can be low or can be the same as would have been for anybody else. So it could be a win-win situation because a government obviously is perpetual, irrespective of who's in power. These funds can wait for the money to come back once these processes are taking place. The priority of these payments will still remain the same as they are today in the code. It's just that it will be an easily accessible fund for the RPs. And these can be monitored, can be audited, can be looked into, can be made sure that the fund and the RP both are in sync with each other while they are doing this interim financing transaction. Now, coming from that, of course, is the fact that maybe a sale of an unencumbered asset, which is a rarity in these cases, as Ms. Maya has also mentioned, there's hardly anything left sometimes to sell to recover money from. Though that could be a fix to interim financing, and the courts will allow that in certain cases, but that is a rarity, I would say, in such a situation. Also, one thing where some problems are coming is that the RPs may not know how to manage the money there. Money which is already lying in the company, or they're not able to find access to those money. So that is another issue, that by training the RPs or giving them the right access to professionals in their team is something that also needs to be looked into and sanctified into the code itself, especially employees which are already working in the company. And in rare circumstances, if the management is on board in helping to restructure. I do believe that there is no dearth of people who can run the companies with the RPs. It's just that as soon as somebody sees a sinking ship, they try to run aboard. They're like, no, we don't want to be part of this company. We don't want to be an employee anymore. So things like that kick in. So maybe some sort of a mandate, some sort of a some sort of a change in the law which requires that certain KMPs need to remain on board on the company. Again, make sure that their salaries and everything is protected, because of course you can't force somebody to have a livelihood and not pay them salaries or whatever. Things like that, at least in huge entities, can be looked into. In smaller entities, it might be a little more of a problem. But nonetheless, finding this kind of solution where the RP is assisted and not like as soon as the RP steps in, everybody just abandons ship. And not letting the RPs also feel the burden of the work by themselves. That was never the intention of this code. It's not that the RP comes on board and everybody goes like, okay, we are done. One single RP will now handle the entire company. They can't. It's impossible for them to do all the things that the code requires them to do and be able to, in the meantime, find money, get interim financing, hold meetings, take up claims, send out notices. All of this is impractical. It's not possible. So ensuring that one side financing is being secured for the company. On the second hand, ensuring that the people working in the company are also helping the RPs in some way. There have been decent enough examples where the management or the ex-management have helped, especially because they were professionals themselves. But most mom pop companies, how we refer to them, and they have gone into insolvency, or real estate entities, which have been huge debate upon. Those are the places where RPs are facing a lot of issues with regards to who is going to help them understand what the company is doing. I wouldn't want to blame any of the professionals who are RPs, but there is a slight lacuna in our understanding of what their job is, and also that they need more training. I understand most of us are company secretaries, chartered accountants, cost and work accountants, MBAs, and lawyers, of course. But none of us are businessmen per se, maybe except those who are MBAs and they know how to run businesses. That training for the RPs is also a job of the IBBI to also maybe sort of do, so that they know what is that they're looking for, what and how to find that, how to run entities like a businessman and not run them into the ground, and not be looking for that ex-management or those employees to run. Yes, it's needed, but if it's not available, the RP should be equipped enough in terms of their training to know exactly what to do next. They should not be left to their to their perils or to the devils to know what to sort of play it by the ear. That cannot be a situation in this kind of a setup of the insolvency code. Now, again, as Mayaji has already summed up what all problems are being faced. So one of the problems was that how do you deal with ex-management? Because they are your biggest almost enemy, if you would say. I wouldn't want to use that word because some ex-management definitely is on board and helping to restructure and even bidding and being the SRAs and everything, but most of them are not. And they somehow see RP as a villain in their life. Though RP is only appointed by the court acts almost as an officer of the court, is a custodian, is somebody who's helping to restructure and run a company which they have run into the ground. So people should not be so, and like animosity is almost coming out towards the RPs, which I think is also something that the courts and the IBBI should look into, that RPs cannot be treated like this. That's something that they need to incorporate in the code, make it more stringent, that if you act a certain way, apart from the fact that you're trying to defeat the law or cause some sort of a hindrance in the law, but if you are, I have heard about physical violence against the RPs. I have heard them being dragged out of the registered offices. I've heard them no access to registered offices. I've heard abuses being told to the RPs. Like, how is that okay behavior towards a professional whose only job is to take over the company and take over certain things? That is another problem, because it deters people from becoming RPs. Or if not women might find it like absolutely something that they don't want to do. So that kind of a behavior first needs to be checked and punished, as I genuinely feel that a professional cannot be treated the way they are trying to do here. But having said that, where the courts can step in or where the changes can be brought in is, number one, the kind of complaints the ex-management can file. The IBBI should not be taking cognizance of all sort of complaints against the RP. And they need to, first of all, make sure that there are certain guidelines put into place, that if the RP has violated these specific guidelines, which should also give the RP certain powers, only then can a complaint lie against them. It cannot be that every sneeze taken by the RP is being reported to the IBBI. It increases the work of the IBBI. It also decreases the validity and the sanctity of the position of the RP, who is supposed to be unbiased, unparalleled person trying to resolve this issue which is being plagued into the company. So every complaint needs to be monitored. What are those places where those complaints can be filed is something which also needs to be discussed. Similarly, where the courts can step in is very critical ways of finishing the applications filed against the ex-management in the most time-bound manner, and issuing strict directions and strictures against the management. Now, the management sneezes out of the RP's control, that should be the one where the courts should step in. We cannot give the ex-management, which is not helping the process, no leverage can be given to them in any manner. That is where I think one of the first amendments or changes or guidelines or regulations need to be brought in as to the way the management behaves with the RP. Their non-cooperation should be looked into, and their non-cooperation should be almost punishable if they try to not give the documents or whatever that is required. There is a third way, which is not so litigious, I would say. The third way is to make sure that the management is involved. Instead of telling the management to back off, we may be able to see it, and that is what happens in foreign jurisdictions. Let the management be fully involved in the process of restructuring. If we see that every management is a wrongdoer, we will not be able to find resolutions to our insolvency problems or liquidation. We have to give that benefit of the doubt to each management, that what they are doing or what they had done was not on purpose to cause insolvency into the company. Hence, they might still be the right people to run this company. Yes, there are many cases where the management has been fully involved and they are allowed by the NCLT or by the court to assist. But let's try to make sure that we get some sort of a guideline or rules or basis to be given to the management, that look, you do this if you want to be in the good books of the court and of the RP. apart from giving documentation, be actually involved, but under the ambit of what the RP is allowed to do and not do. Now, training of the RPs I've already discussed. I think how company secretaries or chartered accountants have continuing education. Every few months you need certain CR, your certain credits are needed. I think something like that can be done for the RPs as well. Something like what we are hosting today, I think that could also be helpful. Just discussing problems comes up with solutions. And those solutions are how each professional can teach each other, like CSs can teach lawyers, lawyers can teach chartered accountants can teach lawyers. However, we can, as professionals, we can sit and see what are the issues being faced and how to move forward. So that continuing education for the RPs is also very important to make sure that they know industry specific issues can also be sorted here. We can have industry experts. And having said that, one of the suggestions that I would like to make to the IBBI, and maybe we can suggest to them, is empaneling professionals with the IBBI who the RPs have access to at reasonable cost and accessible, which is quick and justified. So for example, if there is aeronautics, or like for Jet Airways was one of the cases, or if Go or Vista, any company which can come in. Now, every RP cannot know how to run an airline business, and it's not an easy business. It involves engineers, and it involves aeronautical engineers. It involves so many specialized fields. In such a situation, it's not the RP's fault. He's a company secretary, or he or she is a company secretary, a lawyer, a chartered accountant, limited access to what they know. They cannot know the in and out of what a good engine is, or what engine should be procured, and whether Boeing should be the one, or whether Airbus should be the one, whether it be Bosch and Lomb, whatever, whoever, or GE, whoever supplies these engines. In such a situation, if there is an empanelment with the IBBI of aeronautical engineers, or engineers, if nothing else, who can assist at a decent price to tell the RP, look, as professionals, we believe you should do these XYZ things. That should solve half the problem of the RPs right there. We have independent valuers which are impaneled. We know who to go to. Similarly, we should have even lawyers. We can have engineers. We can have any sort of architects. I mean, depends if these are real estate entities. We can have contractors. We can have any companies, any sort of professionals, any big fours, consultants, MBAs, marketing, advertising, anything. All of these should be impaneled so that easy access, reasonable cost access to the RP, to known people who are experts in their field, and that once achieved by them will help them run the companies in a much sophisticated, in a much clearer manner. And I think that should be one of the suggestions which should also go from us as professionals, that look, give us access to the right people so that we are able to do what we need to do. Now, I had a whole bunch of things what I feel are the issues we face. So, and I think Maya ji covered most of them. So I see where the issue still comes is legal issues, that the RP has to go to court more often than he is supposed to go to the company. They are involved in so many applications that RP does not know that when to run the company or when to go for cases to the NCLT. And despite the fact that they're represented by the lawyers, they still are supposed to be present most of the time because the court might ask them certain things. So the multifarious things of how much litigation we want in these matters is also something to be looked into. So obviously it will come from the industry itself and from professional itself, that not everything should be going on. Not everything deserves a day in court anyways. So the RPs have to consolidate their litigations, consolidate their applications. Some more independence to the RPs under the code is to be provided, so that not everything requires the adjudicating authorities stamp on it. Certain things should be automatic. Like I said, if there's an empanelment, they might just be able to do certain things on their own. Similarly, like if there's a sale of asset and that asset is unencumbered and is twice the price, all of that is also automatic for them to sell. Similarly, more automatic mechanisms, of course, checked. They have to be checked. They have to be subject to final approvals. But if they can be given more freedom then and not be allowed to go to court or not be asked to go to court for every approval. That is also something that the RPs should look into. Now, one big issue which is also faced, and this is going back to the problem with the management, is the records. Sometimes we are not able to find any records. The management has not filed any records. They have not maintained any records. One of the biggest reasons for them to go into insolvency is because they don't know what they're doing. They've just taken a loan and just running the company as their own fiefdom. How is that problem to be solved? And that is something I think we had previously also discussed in one of these seminars, webinars. And this was also discussed with the PhD CCI also, that though we have now the information utilities to make certain documentation and to make records of default, and that record of default is very objective. Similarly, prior to the CIRP even starting, can we have some sort of a custodian of records, or the ROC is given that task, that the information is to be fed into it by hook or by crook by the management? Some compelling authority, some compelling law, some compelling guideline which says that you have to give this information so that the RP is not running pillar to post to get that information. For example, how we had in BIFR, that the first reference would be filed at 50%, a net worth erosion. Similarly, banks know, or NBFCs know, at least sophisticated lenders know, that when the company is going into an NPA or about to go into NPA, or they have first EMI has bounced, anything of that sort, there can be a trigger warning right there and then that, look, this has happened. I want a fresh KYC. Or let's not even wait for that. As soon as loans are given, certain documentation will have to be uploaded with the ROC or with another new authority or with the information utilities, anybody, any authority which takes over this task of taking documentation from the corporate debtors or from debtors and make sure that this information is readily available to the RP as and when, if the company goes into CIRP, so that they don't have to chase anybody, the information is available to them. That kind of a suggestion also now needs to be really looked into, because this seems to be one of the biggest problems that the RPs face, is trying to get documentation. And there seems to be no solution forthcoming for it till date. So I think those are more or less the points that I had. I really believe that RPs are facing a lot of issues. It's not something that we can finish off in like half an hour, 1 hour, 2 hours. It can go on and on. But as professionals, I feel that we all need to sit together and break our heads and maybe provide suggestions to the authorities and regulators as to how this insolvency process can be amenable to everybody. In our country, unfortunately, when the law is made, we look how to defeat it. Let's try to find reasons of how to make sure that the law is a success. It is, but how can it be eased into being a success? So just those my few cents on that.
Thank you, ma'am. Your deliberation was really very exciting and engageful. I guess all our questions are almost answer. आपने बहुत comprehensive way में, बहुत detail में, बहुत अच्छे से सब बताया. आपने प्रॉब्लम्स भी बताई, सॉल्यूशंस भी बताए, सजेशंस भी दिए. मैं प्रवीण जी से कहूँगी कि वी हैव नोटेड योर सजेशन एंड मे बी हम लोग कभी उससे आगे फॉरवर्ड करेंगे. एंड हमारा हमको बहुत खुशी होगी क्योंकि चौधरी सर अगर नेक्स्ट सेमिनार में आए, वी ऑर्गेनाइज दिस वीकली सेमिनार्स. अब की बार वो नहीं आ पाई, दिस वाज आवर बैड लक. And
so next time definitely I'll make sure I am with him to make sure.
Yeah, sure, ma'am. आपका topic इतना अच्छा था कि I am sure कि all our audience are would be willing you to hear you again in our next upcoming webinar. प्रवीण जी की हमेशा कोशिश रहती है कि हम लोग वीकली वेबिनार करें. यूजली हर सैटरडे को 4 to 6 हमारी वेबिनार होती है. कोई टॉपिक आप लोग भी सजेस्ट कर सकते हैं. Any of the audience can suggest the topic. And Praveen sir will be most delighted to have them on board. Now the floor is open for the audience. They can raise their hand and unmute themselves and ask the question. Sir, Harsh sir, Harsh Adya sir, आपका question.
मैडम I am Rajesh Kuru from Cochin. I have a problem with my video, so kindly excuse me. May I ask a question to Maya Madam? This is a unique issue which I am confronting as an IRP. So I was appointed under Section 9 petition, and the COC constitutes the procedural requirements were met. Report was filed with the NCLT. The COC comprise of only one FC, that is a banker, a scheduled bank. And the first meeting was conducted. It was a physical meeting at the instance of the COC member. And the minutes were circulated as stipulated within 48 hours. But there started the problem. There is absolute, silence on the part of the COC member. They do not respond at all. They do not. I have sent the reminders to my mail sending the minutes. Actually, what transpired at the meeting also was that the COC member was not responding at all. Whatever items for which a decision was required, that is confirmation of IRP or replacing the IRP, and again, ratification of the CRP cost. Nothing was, the absolute silence on the part of the COC member. They said that they require time, they need, confirmation from their higher ups. So fine enough. I send the minutes and advise them to vote as per Regulation 25. But again, as I told you, absolute silence. They don't respond to my mail. They do not pick up my phone. So there is a stalemate, so to say, because as much as I understand, the requirement of Section 22(2) has not been met. Because the first meeting, either confirmation of IRP to RP has to take place, or replacement has to take place. And despite the same, see, how am I to proceed with? Because even the duty of RP, what it says regarding that, regulation Section 25(2)(f), that is the criteria for inviting EOA, there has to be confirmation from COC. So in all those respects, unless and otherwise I hear from COC, how am I to proceed further? So this is an issue which I face. What am I to do, madam?
So these issues are similar to as I have faced in my previous assignments as well. So you can't do anything. You need to report completely as well as to the IBBI, and you can submit your status report with the AA also. And as per the amended regulations, you need to continuously send notice for the subsequent meetings.
You mean to say subsequent
Only
meetings
the
have
compliance
to
part,
take?
yes. Yes. You
that is,
need to every time place those agenda matter before the COC. You convene the COC meeting and place those agenda matter unless they are approved. Because in the banker side, they always have these problems that they do not have the authority to approve the IRP as a RP. They always find a person from their panel at a least cost. So
that's fine enough. Actually, madam, you said that. I had actually aired that also at the meeting. You are free to appoint an RP of your choice. I expressly told them. You don't actually, I am not at all.
That's true, but they do not have the power to take decision. So I have also faced these challenges, and the best way to you must comply with the provisions of the code. You must submit to the IBBI along with the minutes of the meeting and the email correspondence. You need to submit a regular correspondence with the COC member and regularly submit the notice for the next subsequent meetings. I
filed the CRP 7 that has already been filed with IBBI, but this minutes and all I did not, because as much as that has not become
that you need to there is an email with the correspondence with the IBBI. You regularly send updates along with the correspondence. I was
wondering whether I need to take a direction from the AA at this point of time, because 22(2) has not been complied. That's what I see. technically, how am I to act?
Right, exactly. If there is something in the company's assets, then you pursue this. If the company has no assets, then you file with the AA for early dissolution.
Assets are there. I have taken custody. I have put a security guard also there. All those things.
You submit, yes, you submit the report with the AA and ask the way forward and continuously pursue the COC members. This is the only, in my previous cases, it took about 6 months to regularize IRP as RP. But being a professional, we have to comply with the IBC provision. So take your 40 days as your deemed RP that required with the IBBA regulations to upload at the IBBA website and continue your COC meetings regularly.
Okay, madam. Thank you so much. Thank you.
Thank you, sir.
Hello.
Hi, sir. You can go ahead, Harsh, sir.
Sure, ma'am. Ma'am, my concern is with Manisha ma'am's one thing that the law should basically restrict the KMP to be in the company. Ma'am, even if that is made, wouldn't it be violative of Article 19(1)(g), basically freedom of profession? Like,
Yeah,
can
see, that's
the
what-
law rightfully restrict someone from being or not being in the
That's,
occupation?
Right. I appreciate what you're saying. That's exactly what I mentioned, that we can't hold back people into working into the companies. I hope you heard that part as well.
Right.
So the idea is that reasonable restrictions can always be put in. So it's not like as soon as the RP comes in, they jump ship. If we say that there will be a proper notice period to be served, there has to be documentation to be handed over, their KMPs will have to take care of take care of a company going into insolvency for 3 months. I don't think that is violative of the Article 19 at all. I think
In fact, ma'am, I had a follow-up to this because IBC, the code nowhere gives it the freedom to an RP to basically resign.
Right.
So isn't it that itself a violation? Because they should be free. Even in companies that there's a freedom to resign for directors, every other professional has a freedom to resign. But if it's not given to RP, aren't we taking away some of his rights as a professional and as a person?
I think RPs have by their own volition chose to be part of these companies. But
Right.
I can agree with you. I hear you on the fact that if the RPs feel that they have to resign and that they cannot take care of this company, that assignment itself should be, that is the resignation from that assignment should be allowed to them.
Right.
Following the process of them asking the COC, this whole thing as well can very well go. So they can always.
So has there been any clarifications or judgments on this part where the court have said that yes, they can resign with all the consent, all of them being consented?
I have not come across in my clients and my clients for RPs, but maybe Maya ma'am knows. I'm not sure.
Sir, since in the CIRP, yes, in the CIRP, COC is supreme to take decision of all these issues. If you go these issues with the place before the COC and by the resolution, if you take any decision and that report, if you submit with the NCLT, that would suffice your purpose.
Okay.
Yeah,
because you need to frame certain grounds why you want to, give a notice period to a specific KMP.
No, not just that. I think we can withdraw your consent as an RP as well. So if your terms and conditions as an RP are not being met, withdrawing consent should actually do the job, and then the court will be left at its own peril to appoint another RP.
Right.
Yeah, so that could be your answer as to what is to be done, and withdrawal of consents are absolutely allowed.
But then, ma'am, like of course it would take its own due time. The court might decide like month, 2 months. It would take time, and within that period, if the RP is not performing his duty, it would then again fire back to him कि hey, you were still there but you didn't perform. Like just a discussion.
I absolutely
Yes, yes.
understand your judgment, your concern, but that's 1-2 months is nothing when it comes to a professional leaving a profession which is of fiduciary duty to themselves as well. They RPs have much higher duty to the company that they have taken, and hence that consent concept is there. And if they've taken that, then their resignation or their withdrawal of consent will also require a little more patience on their part. That's what I feel. And like I said, they're too burdened in this whole process.
Right. Let's hope it evolves for the better.
Right.
Thank you.
Any other questions? Shailesh, would you like to share your thoughts? Shailesh Ahoja, sir, would you like to share your thoughts? Kindly introduce yourself and share your thoughts.
Very informative webinar, and the detailed information and based on the best practices. This is very informative, and for those IP who are new, like Mr. Yuraj Tiwari, he's here. He's just joined and passed the exam in the last week. So for these persons who are recently joined in the profession, this session is very good, very nice, and I appreciate all the speakers, and thanks to the organizers. Thanks, madam.
Thank you. Anyone else want to share his thoughts? Naren, sir? Naren, sir, do you want to share your thoughts? Okay, as we come to the end of this knowledge pact section, let me wrap up with the bow. Thank you to our incredible speakers, to our guest star of honor in absentia, and brain behind GPAN, of course, all of you for being an engaging audience. See you in the upcoming webinar. And now I would request Praveen sir for formal vote of thanks, sir.
Thanks on behalf of GPA. We are very thankful to our guest of honor who could not join due to technical glitches. With his support and NCLT Bar Association, and also to CSIP and Advocate Maya Gupta ji, and Advocate Manisha Chaudhary ji, who is our speakers, and our colleague Mr. Manoj Anand, and Pallavi ji, monitor of the session from Lucknow. He is very sincere in this regard, and all the participants. I am very thankful, and thanks a lot. Namaskar.
Thank you. Thank you.
All of you.
Thank you.
Wishing you a great week ahead.
Thank
Bye.
you, everyone.
Thank you, sir.